Welcome to Module 6 of Ombudsman Associate Certification Training. In Module 6, we will be discussing resident representatives. This module is about 24 minutes long. This module will be discussing resident representatives. Residents aren't always able to speak for themselves or manage their own affairs. In these cases, ombudsmen need to have knowledge to the types of representatives who can speak on their behalf and how they should come to these decisions. We'll begin by discussing resident decision-making and support, including options involving the principles of decision-making. Next, we'll go over what Ohio requires of the different third-party decision-makers. And finally, we'll wrap up by talking about Ombudsman program policies and working with residents and resident representatives. Learning objectives for today are for Ombudsman representatives to communicate accordingly to the capacity of residents, understand and be prepared to apply the appropriate decision-making principle based on that determination, and have knowledge of the different types of resident representatives based on resident capacity. We'll start off on Section 1 about decision-making support and options. A resident's capacity to make decisions is at the core of how an ombudsman approaches a complaint. It derives from the resident's inherent right to self-determination over their own quality of life. Ombudsmen are resident-focused and seek to further a resident's right to self-determination whenever possible. When approaching a resident in our advocacy, we will first need to determine the resident's capacity to make decisions, which we'll discuss in detail coming up. In a future field assignment, you'll be asked to meet with at least 4 residents. You'll discuss with the staff ombudsman the resident's capacity, what you considered, and the factors that led to your decision. Additionally, based on whether the resident has or does not have capacity, you'll determine the level of decision-making that would be used and how the ombudsman would advocate for their known or inferred preferences and values. Capacity is different from competency. The degree to which you will know a person's capacity isn't a clinical or legal determination. Capacity is a resident's ability to understand the situation around them and discuss what they would like as an outcome. Capacity isn't a black and white analysis and is not determined by an individual's ability to verbalize their wishes. Thus, if a resident isn't able to express themselves verbally, it's still appropriate to consider their capacity. Residents can have capacity over some areas of their life and not others. For example, a resident might not have capacity to make major medical decisions, but they may be able to tell you if they are in pain or what they would like to have for lunch. A resident's capacity also may vary by day or time of day, so it is important to be flexible and open-minded in considering a resident's capacity. It's inappropriate to decide that a resident doesn't have capacity based upon what we think is a bad decision, and to do so contradicts a resident's right to self-determination. Competency is a legal determination that a resident is unable to make decisions over certain areas of their life. Competency is broader than capacity, and a resident may still have capacity, although they may have been found by a court to be incompetent. We'll discuss later on how to navigate situations where a resident is determined incompetent and appointed a guardian, while they still may have capacity in certain areas of their life. We're going to talk about 3 levels in the principles of decision-making. They're used based on the resident's capacity and any potential representatives involved. In order of least restrictive to most restrictive on a resident's right to self-determination, they are informed consent, substituted judgment, and best interest. Informed consent is when the resident exercises their autonomy to decide for themselves based on the information provided. The resident's decision is the controlling factor in decision-making, and they are given the freedom to make a choice without coercion. Informed consent includes the resident being fully informed of their choices, alternative options presented neutrally, risks and benefits of their decisions. Substituted judgment is used when the resident's representative, whether they're legally authorized or not, is in the position to decide on behalf of the resident. The representative uses the resident's values and preferences as the controlling factors to deciding. The representative should reflect about the resident's past expressions, decisions, and other actions which would indicate the resident's personal values and preferences. This could require the representative to talk with the resident's closest family and friends, or looking into how the resident lived, or other choices before their loss of capacity. Best interest is typically seen where there's a guardianship involved. Best interest decision-making requires the resident's health and welfare to be controlling factors in the decision-making on behalf of the resident. As discussed, when we talk about guardianships, a guardian must make decisions that are in the best interest of the resident. Whenever possible, however, the guardian should use substituted judgment and make those decisions based on good information. Ombudsmen should seek informed consent from residents to the greatest extent possible. This can include being flexible with the fluidity of a person's capacity. If a resident does not have capacity, then the Ombudsman should work with the resident's representative and advocate for the representative's use of substituted judgment, considering the resident's preferences and values. Remember, the goal of substituted judgment is to make a decision that the representative believes the resident would make for themselves. Using these approaches will support the resident's dignity of risk. Keep in mind that the resident, in deciding for themselves, may not be a decision we would make for ourselves, but that the resident is able to make decisions that might include risk, and they're dignified to do so. We're going to talk through some scenarios where an ombudsman is working with a resident. These different scenarios will vary in the resident's capacity and the family or representative involvement. The goal of this exercise in scenarios is to consider who will be making decisions and which principle of decision-making is at play. So for scenario 1, the resident can discuss with you the nature of the problem and give you an identifiable goal. There is no representative involved. So in this case, who is making decisions? And what is their level of decision-making? So in this scenario, the resident would be making their own decisions for themselves, and this level of decision-making is informed consent. For scenario 2, the resident is able to communicate through nonverbal means the nature of the problem, but the family does not agree with the resident's goal. So who's making decisions, and what is the level of decision-making here? So in this scenario, the resident will still be making decisions for themselves. As it states, they're able to communicate through nonverbal means, and the level of decision-making is informed consent. The family does not have to agree with the resident's goal if the resident has capacity. Scenario 3. The resident is unable to understand the nature of the problem and cannot explain how they would like the problem to be resolved. There is family involved who has power of attorney to make decisions. So who's making decisions here, and what is the level of decision making? So the resident lacks capacity in this scenario. So the person making decisions would be the resident representative. They would be the decision maker here. We're still representing the resident's interest, and the representative should be applying substituted judgment as the level of decision making. Moving on to scenario 4, The resident is unable to understand the nature of the problem. The family member is the resident representative, but seems to be making a decision in conflict of what others involved believe what the resident would want. So in this scenario, who's making decisions and what is the level of decision making? So here, the resident lacks capacity. They're unable to understand the nature of the problem. So the resident representative will be making decisions on the resident's behalf. And in this scenario, the ombudsman should be diligent in advocating for substituted judgment, that the resident's values and preferences are controlling factors in decision making. Moving on to section 2 of this module, state laws on third-party decision makers. So there are several types of resident representatives. Listed here on this slide are the more common types you'll likely encounter. Regarding representative payees, these are often seen when the resident is a Medicaid recipient and they have designated the facility or another person to pay their monthly liability payment. Basically, a representative payee just assists the resident in managing their money. Attorney in fact. So a power of attorney documents, authorizes another person to act on behalf of the resident. The document can grant the attorney in fact complete authority, or it can be limited to certain acts and/or certain periods of time. If the resident does not have capacity, the power of attorney document should have a durability clause saying that it is still in effect when a person doesn't have capacity. A durable power of attorney for healthcare is a specialized kind of power authorized in Ohio law and is only in effect after a physician documents that the person doesn't have capacity. Some people tend to get confused about what power of attorney documents actually give them power to do so and when. So regarding a guardianship is appointed by a probate court judge after a person is deemed incompetent. A guardian has to make decisions based on the individual's best interest, but Ohio rules do require that the guardian gets to know the resident, sees the resident on a regular basis, and engages the resident's family. Sometimes a best interest decision-making approach will involve what is best for the resident, although it might not be what the resident likes. There are some different types of guardianship listed here on the slide. So a limited guardianship is when a probate court appoints a guardian over only a portion of a person's life where they're deemed incompetent and have a need. It can be limited to medical purposes only or providing consent to services. A guardian of person is a guardianship that provides the authority to make day-to-day decisions of a personal nature on behalf of the individual, except they cannot make financial decisions. This type of guardianship includes things such as arrangements for food, clothing, living arrangements, medical care, recreation, and education. A guardian of estate is a guardianship appointed only over the individual's assets and financial needs. This type of guardian has no authority to make healthcare or other personal decisions. And finally, a plenary guardianship is one where the guardian is over person and estate. These are the most common types of guardians. A healthcare power of attorney, also called a durable power of attorney for healthcare, is a legal document that authorizes another person to obtain health information and make healthcare decisions for a resident. The individual or the agent can obtain healthcare information at any time, but the ability to make decisions on behalf of the resident is in effect only when and if the resident cannot make healthcare decisions for themselves. The person under a healthcare power of attorney is required to make decisions that are consistent with the resident's wishes and the power of attorney will not overrule a living will if the resident has one. A power of attorney is also limited in that there are certain decisions an agent under a power of attorney cannot make. They cannot withdraw life-sustaining treatment unless certain conditions are met. They cannot withdraw artificially or technologically supplied nutrition or hydration unless certain conditions are met. And they cannot withdraw healthcare treatment that was previously consented to unless it is significantly less beneficial. And they cannot withdraw treatment to relieve pain. In Ohio, the financial power of attorney is a legal document that the resident can use to appoint someone to act on their behalf regarding personal, financial, and business matters. We usually see this in the context of paying the resident's share of cost or assisting the resident with applying to Medicaid. The individual who's appointed must act in good faith relating to the resident's reasonable expectations. The resident establishing the power of attorney establishes the scope, but in general, the financial power of attorney can manage the resident's financial affairs. The financial power of attorney is prohibited from making a trust or changing an existing trust. They cannot give away property. They cannot change beneficiary designations, and there cannot be other financial changes in regard to annuities. As mentioned before, a guardian is a person or association appointed by the probate court to be legally responsible for a person who's deemed incompetent and or their property. Only courts can appoint guardians upon a supporting statement of incompetency following an expert evaluation. Family members are given preference for appointments, but anyone can ask a court to appoint them as a guardian. Guardian powers are limited by the authority granted by Ohio law, orders, and rules of the probate court. Guardians must obey the orders and rules of the probate court that appoint them. Guardians are required, in considering the individual's preferences, values, and goals, to make decisions in the best interest of the individual. However, in spending the individual's money, the guardian often must seek the probate court's approval. As discussed earlier, there's a guardian of person and a guardian of estate. The guardian of person is appointed to make personal decisions for the individual, such as where they live and how healthcare services will be appointed. The guardian of estate is appointed to manage the individual's assets. Guardians are required to file reports with the probate court to show that they are conforming with the court's requirements of the guardian's contract. Moving on to section 3 of this module, we will talk about program policies about resident representatives. So even if the resident has designated a representative or has been appointed a guardian, we do not automatically defer to that representative or guardian. The Ombudsman is resident focused, and we must meet with the resident and consider their capacity first. As mentioned earlier, if a resident has capacity, we will work with them to reach their goals and preferences, despite there being a power of attorney or guardianship in place. That could include promoting the resident's autonomy by advocating with the representative to make decisions in alignment with the resident's goals and preferences. In promoting autonomy, the Ombudsman should lead by example by respecting the resident's right to self-determination. This could include educating providers and representatives on the resident's right to self-determination and to be honored and exercised to the greatest extent possible. This also includes where the resident might lack capacity, that the representative should make decisions as close to the resident's preferences and values as possible. So back in Module 1, we discussed the Ombudsman Code of Ethics. This is specifically important when working with resident representatives. Ombudsman services are to be provided with respect for human dignity and individuality, unrestricted by age, socioeconomic status, personal characteristics, or lifestyle. The value of personal autonomy is rooted in the resident's right to self-determination, which is to be supported in our Ombudsman work. As Ombudsman, we have an ethical obligation to make every effort to act in accordance with the resident's wishes, even when there is a resident representative involved and in effect, whether that's a power of attorney, a guardian, or otherwise. These efforts and meeting these obligations will also fulfill our ethical obligation to protect vulnerable individuals. In this context, it is the individual who is subject to a resident representative making decisions on their behalf. So some examples of these. One, if a resident who has diabetes would like a sweet treat, such as a soda or a piece of dessert, and the provider is resistant and the resident representative wishes for the resident to not have the soda or dessert, in this case, the Ombudsman should advocate for the resident's preferences. This includes advocating that the provider tell the resident the risks, benefits, and accommodate the resident in enjoying the treat in their given condition. This might include closely monitoring their sugar levels and responding accordingly. The Ombudsman should educate that the resident still has the right to self-determination and can decide to take risks. One way to look at this is to consider that if the resident were in the community, they would be able to make that decision for themselves. A second example, if a resident who is appointed a guardian wants to live in the community, the resident is mostly independent with their activities of daily living, like bathing, dressing, feeding, and going to the bathroom. In the past, the guardian has not been agreeable to the resident living in the community due to concerns stemming from choices the resident has made in the past. In advocating for the resident's preferences and values, Ombudsman should get an understanding to the guardian's specific concerns, as often those concerns can be alleviated by community supports. Should they be reasonable, attainable, the Ombudsman should advocate for the resident's preferences and values. A resident recently moved into a nursing home and has a power of attorney that is documented into effect for this example. Let's assume it's determined that the resident lacks capacity. The nursing home has arranged for the resident to have assistance showering once a week. The power of attorney accepts this, believing that this option is the only option available. The Ombudsman, through our investigation, learned that the resident often showered every other day when in the community. This was important to them before moving into the facility. The Ombudsman should educate the power of attorney of the resident's right to participate in decisions regarding their care, which would include a shower schedule. Additionally, the Ombudsman would advocate for the resident to receive some showers in alignment with their values and preferences, as evidenced by their shower schedule before moving into the home. That concludes Module 6. Thanks for watching.